Good morning.
Good morning.
Morning.
I hope everybody had a wonderful, peaceful Memorial Day yesterday. Okay, we're going to go ahead and get started. Today, I'm going to talk about three things, right? Not one, not two, but three things. And part of it is because we are in the throes of approving forms for Texas Realtors. TREC came out with their meeting at the beginning of this month with some things. And then we're going to talk about your understanding and use of terminate versus default. What I have a lot of agents call me and say that the buyer didn't close at the closing date and they want to terminate. Well, terminate and default are two entirely different definitions when it comes to real estate. And if you misuse these terms or use them interchangeably, you could be in trouble because you never want to give the wrong understanding of terminate or default to your clients. And so that's why we're going to go through that today. I've just been getting too many of those, and I think we just need to kind of set it straight on that. As I'm going through my presentation today, remember to, if you have any questions, just interrupt me, take yourself off of mute and interrupt me and ask me while I'm going through it. The chat has really sweet things. So most of the time it was good morning or glad to see you and welcome. So the first thing I'm going to talk to you about is TREC. TREC had a meeting in early May, and that meeting proposed changes to the TREC temporary residential leases. We use this quite a bit in our transactions, so you really need to understand what is happening. Our association, Texas Realtors, was on the ball. When the law changed January 1st for landlords, they had the addendum regarding residential rental flood disclosure, right? They were right there on the spot. They gave us the form to use that is mandated by law that all landlords comply, okay? Well, TREC found out that even on the temporary leases, it is going to be required, okay? So they're modifying the temporary leases to have language that will talk about the residential rental disclosure. TREC is creating their own. Texas Realtors has theirs. At the last time we met last week, they decided that TREC said their form would be voluntary. Why? Because Texas Realtors already had a form, okay? And so in this instance, this is going to be mandatory when your transaction needs a temporary lease. You will also have to attach the rental flood disclosure to it. Now, how does TREC go about making all these changes? Well, they propose the changes, and then in the August meeting that they'll meet, they're going to review all the postings that have happened since they actually posted the proposed changes. Once that's done in August, they'll either decide to send them on without any additional changes to the TREC Broker Lawyer Committee, and then TREC will usually vote on it in November. And then it becomes mandatory for us. Sometimes our use of it like right away, sometimes it's a month. So again, those are the types of things that you have to stay plugged into training because there's so much going on and changing right now in our forms. And the biggest problem is when agents use forms that are no longer current. And what I mean by that is if you use a repealed form, you're in violation. We can only use the current forms either by TREC, based on what is mandated by TREC to use, which is most of their forms, or Texas Realtors in the event that they provide us forms. And so I'm going to go through some of those changes today. I know which ones from my task force at Texas Realtors were approved. We're going to know the rest of them. And then next month, what we will be doing is reviewing all of the forms that have changed because Texas Realtors told me that by mid-July, they will have the forms posted and ready for your use. That means once they post them, you can't use the old forms anymore, okay? So we'll get started here on our proposal. Okay, so some of the forms that I'm going to talk to you today are in draft form. That doesn't mean that they haven't been approved already or maybe changed with approval and those types of things. The biggest ones are the listing agreements, both for sale and for lease. I'm going to point those changes out. The seller's disclosure, the residential buyer tenant agreement, and the buyer's final walkthrough. And there are a couple of lease forms I'm going to pay a little bit of attention to, but we're going to review those more in depth next month when we know what the committee has approved on that. I keep having to bring in people, so I'm so sorry. It's hard for me to do two things at the same time, but I'm going to try. Okay, so right now we're going to bring up, let's see, our draft document. The first one we're going to go through is the residential lease for sale, right? A lot of us use that quite frequently, and there have been a couple of changes in it that reflect more balancing and putting in provisions so there's better clarity whose responsibility is. And in paragraph 12, seller's representations, they've added a provision that says the seller, and this is true, the seller is obligated to tell you if the property is located in a public improvement district, a PID, a MUD, or any other statutorily created districts. And the reason for adding that is because it is apparent that the seller should know what their tax jurisdictions are. Does that take away from your knowing? No, it does not. You've got great resources. HAR is wonderful. All you do is click on water districts and you see various information. You can always go to the districts. But more importantly, when we take a listing, we always have what? A county appraisal district form. And why is that? Because the seller is going to acknowledge that this information that the county has and it's a public record is true, right? That it's current. It is true. And under tax jurisdiction, your seller knows if they are in a MUD or a drainage district number 2 for the county or a public improvement district. So it's not solely your responsibility. It doesn't take away from your knowledge of how to get information about this and know, but they put it in our listing agreement that the seller is now obligated to disclose. So the seller is going to list all of them that apply in paragraph 12 in the new paragraph 12K, and that was approved. The next one that we're going to talk about is default. And we're going to see default, and we're going to talk about default later in the contract and our agreements. And what happened was the language, while it was implied, was not clear based upon what the broker would have the ability to hold the seller in breach of their listing and terminate the listing if they want. And it says if seller does not cooperate with broker to facilitate the showing, marketing, or sale of the property or otherwise. So that does include when you have a seller that you've reached out to and they've gone silent, right? They can't be absent from you, just like you can't be absent from them because of your listing agreement. Somebody will always be in your stead as a listing agent. And then they added to balance because they gave the client this ability. The broker now may also terminate this listing and exercise any other remedy at law. This paragraph's clarity will help a great deal. The problem is that who determines this, right? Well, the broker will have proof if the sellers didn't cooperate or kept denying showings and various other things. I mean, most of it is factual. There won't be that question mark about who breached the agreement. We have had some sellers who fight back when they went silent or didn't cooperate or didn't let us show the property, and they said, well, you breached it first, kind of thing, you know, the finger pointing. This paragraph is in benefit of the broker. These are the broker's agreements. The broker's the only one that will make the business decision regarding termination of a listing. They own the listing and that type of thing. And especially when you're talking about terminating because the sellers have breached the listing or have not cooperated, the broker always needs to be involved in that. The next one is the addenda. What they added was the PID disclosure notice so that you don't have to write it in other here, where you write in any other addenda that you want to attach to the listing agreement, any other forms that you may have, and that it's important that you know that it's now here, it's applicable in the event the sellers have notified you or you are aware that the property is in a public improvement district. Any questions on those? Okay, so pretty straightforward as far as the draft on the listing for sale. Now on the listing for lease, we have a situation where they had to make some changes regarding the payments of the first month's rent, right? It's in another paragraph in this listing agreement, but apparently nobody reads. And so we wanted to make it clear that the landlord understood that 100% of 1 month's full rent will be paid, made payable to Keller Williams. So you'll put your brokerage name in here. So it's real clear now, the landlord knows. We had an ability in that other paragraph in here to deduct any compensation that was due from us from the fees. Okay, so it was always there. Nobody reads. So the landlord kept demanding to get it, and we said, no, if you need first month's rent made payable to you before you sign that lease, you must give us a cashier's check for the first month's rent. So this is to help assist in the clarity of where that first month's rent was made payable to. And you'll see it also in the lease agreement. The lease itself, they had to modify as well. So in the last changes that they're going to address is a change that they are mandating all over the place regarding various things. So again, the listing hasn't changed that much other than to identify that and to also make sure that you're aware of the landlord acknowledging in writing. Don't ever leave that blank. The next one was the addenda. Instead of you having to put in the addendum regarding rental flood disclosure, they've now pre-marked it. And why was that? It's because it's required by law. Same way as our information about brokerage services, okay? So it's real clear now that we have that already marked for us, so you best always attach it as is required by law for the landlord. Now in the lease, paragraph 20, they stripped the word pets from everything. They're changing the pet agreement to animal agreement, and they changed the word pets to animals. They do differentiate that assistant animals are different than other animals for the purposes traditionally as a pet. But here's the notice. It says broker is not authorized to refuse a valid request for a reasonable accommodation for an assistance animal and may not charge any animal fee or animal deposit for the assistance animal. Why do you think that was put in there? That was put in there because there are some listing agents that are helping the landlord violate fair housing. And you're not going to do that ever. Okay, and it's real clear that your landlord has to make reasonable accommodations. So you're never going to be unavailable to pass that along, that information and request to the landlord timely. And when I mean timely, I mean you're not going to be gone for more than a few hours from giving and passing along the request to your landlord. Your landlord is deemed to need to respond. If they got the request in the morning, they better respond by the afternoon. And that's per the individual who is the enforcement officer for fair housing. So again, leases they go very fast, but you also have a lot of requirements to assist the landlord in complying with. And they put that in paragraph 20 so that the landlord clearly understands we're not going to do that. And that they have to honor all the requests for response for requests for assistance animals. Any questions? Okay, the next one is our buyer tenant representation agreement. They made a couple of changes on this one. The first one was they talk about representations, okay, and they added something, and they added brokers not authorized to execute any document in the name of or on behalf of client concerning the property. Why do you think they had to do that? Is because we had agents whose clients were getting down to the wire, right? And all of a sudden they said, oh, I'm not available, just sign my name, you know, and the buyer agent made a huge misstep. We don't sign anybody's name, much less our client's name, ever. We don't act on behalf of them. We're not a power of attorney for them, none of that. So they had to make sure that you understood that because it's a violation of law. Never. You will never, ever do that. We have a horrible lawsuit right now where the buyer agent did that. And the E&O company now knows that. Whoops. They don't cover you for things that you purposely do. Everybody understand that? These are for accidental omissions and those types of things, not purposefully doing something that they know violates what they're allowed to do. The next change is regarding default. And again, as I said, they're going to try and balance this so that both parties are aware that they have certain remedies, right? And it says broker may also terminate this agreement and exercise any other remedy at law. Again, your broker is going to decide that. But what I am going to tell you, you cannot terminate your agreement if your buyer is under contract. Your broker has the obligation to step in and appoint someone else to take over, right? These are the broker's agreements. You sign in behalf of the brokerage, on behalf of them, but you don't get to make the decision about just terminating once they're under contract, right? The broker must appoint another agent to carry that transaction all the way to closing. The broker can never abandon their duty because the buyer and the buyer agent have gone sideways. That's one of the requirements that you want to make sure you always pay attention to. And the other thing is, in paragraph additional notices, they added the word pest inspector, right? And we got quite a few interesting comments on this during our meeting. Some people wrote in and said, I've never been accused of a pest inspector, but some people have accused me of being an appraiser, right? You have to have that special language because of the differences between our price opinion and what appraisers give is value. We don't give value opinion. We only give price opinion. So they decided that because it's in the general information and notice to buyers and sellers regarding appraisals, that they didn't feel it was necessary to add appraiser here. But this was more about inspections, right? And so they wanted to notate which ones were. You just make sure we're not a pest inspector either. You don't act like an inspector, and you don't act like a pest inspector or compliance for inspector or engineer or anything like that. And then they renumbered all of those. Any questions on those three? Those were 2 listing agreements and then 1 buyer tenant agreement.
That animal provision, it was cutting off on my end. You said that they needed to respond within 24 hours to that one.
Could be even less time than that. The enforcer for fair housing, when they came into Austin at a meeting, they told us that if our landlord got a request for a response in the morning, they better respond by the afternoon. Otherwise, your landlord's going to be fined.
Okay, thank you.
Mm-hmm. And as I said, if you don't know the ins and outs of leasing, you don't do them. You have extreme liability. The problem I see truthfully is that we have too many landlords who think you are a property manager. Okay. And the minute they think you're the property manager, they try to shift your knowledge as being gospel on various things. You're not a property manager. You are a listing agent. Your job is to procure a ready, willing, and able tenant. It is not to function as the landlord. You need to know as much as the landlord, I agree, but you're not going to advise them how to be a landlord on something like that. Okay. Now, this is the seller's disclosure. What happened was we had a huge lawsuit in North Texas. And what it involved was the buyer agent asked the listing agent. The seller marked Y on one of the boxes that says, if yes, attach the TXR 1414. And the listing agent never provided it to the buyer, right? And that's what the listing agent helps the seller comply with this. Well, at day of closing, excuse me, and it was a very sizable property. The buyer said, you didn't give me this, so I get to terminate. And then the lawsuits happened. It went to all the way up to the Supreme Court of Texas, and it was on appeal and all these different things. And so we have removed, if yes, attach it. And I'm going to tell you, I was one of the biggest proponents of this because it was embarrassing how many listing agents had never understood that that was a requirement the seller had to do when using this form, and buyer's agents who had no idea that it was ever on the form and required. It reveals to me that you don't know what your clients sign. And that is one of your biggest duties, is to always know that. So what we did on the bottom of the form is we said, if buyer is concerned about these matters, buyer may consult information about flood hazards, Texas Realtors 1414. It's amazing how many people call me that are from your office when we're doing our session. Okay, so again, this is important. It says buyer may consult information. Who's going to give it to the buyer if they want that? Buyer agent. Okay, that's your duty. It's not the listing agent's duty. It's your duty. It was the listing agent's job to have this. If it says, if yes, attach, absolutely. Make no mistake. That was absolutely on the listing agent to help the seller. But if the form has changed and you're using the new form that doesn't have if yes, attach, and the buyer says, what is this? You will give it to them. I don't know. I wouldn't have a buyer in your area without them having this information, period. Right? It's one of our best ones that we have for that. Any questions? Well, now I'm going to tell you about what we are going to remove that was not made as a request. In section 9, it says seller has or has not attached the survey of the property. We chose to remove that provision. Why do you think we chose to remove it? Can somebody take themselves off a mute and answer it? How do you think we decided to remove it?
Could it be because of the copyright law?
It is. Yay, yay, you get 10 gold stars. It is. And I'll tell you what the problem is. One of the brokers on our committee is very good friends with an attorney in your area that specializes in copyright protections. And they told them that they want to do a class action lawsuit and bring in every broker and listing agent that ever used a copyrighted survey in the transaction. You know what class action lawsuit means? It means at night when we're watching our favorite show and then we get all these commercials about if you've used this product, contact this law firm, right? Or if you feel you've been wrong, contact this law firm. That's what they're doing right now with NAR and MLS. They opened it up for a class action lawsuit against, and they're asking any seller, if you ever paid the compensation for the buyer agent's brokerage, contact us. And my problem is I'm appalled at how many listing agents don't look at the documents that their sellers will convey to the buyers, completed of the seller's disclosure. But more importantly, your sellers could never use an existing survey, paragraph 6C1 of the contract, if it was copyrighted. Does everybody understand that? You have to look very closely. The little copyright symbol sometimes is almost blurred. Sometimes it's not as legible, but it talks about the rights reserved under it. It is very deadly for you to do that. Anybody who's known me, let me see if anybody's on this call that's been around for a while. There's Samantha and many people who know how I feel about use of existing survey. Number one, I didn't like it because the buyer didn't have their own survey. I think every buyer deserves their own survey, right? Number two, listing agents had no idea what 6C1 meant. They never helped their sellers comply with providing the existing survey and the notarized T47 within those number of days in 6C1. There's lots of reasons. Years ago, when we had our forms, it wasn't there. It said either the buyer's going to buy one or the seller's going to buy one for the buyer. And then what happened was the mortgage industry, with all the refis in the early 2000s, said, hey, Trek, we've got this great thing. We've been doing refis with sellers, owners, and they have their existing survey, and we've been using them. You might want to add it to the contract. They are seriously considering removing it from the contract because of the liability under copyright protections. You will never have E&O coverage for that. That means money you have to go to the bank and borrow, or you will have to write a check for it. Our errors and omissions insurance policy. Yes?
Okay. Oh, hi, Marilyn. This is Nancy Slatter. I have a question on the survey. If the existing survey is their old survey from when they bought the property, how does that work?
But that's what an existing survey would. It would only be the buyer who bought it on their previous transaction, not a seller who gave it to that buyer as an existing. Yeah, you can't give something that's not your own.
Right.
Okay. And please don't allow them to use a copyright.
Yeah.
If I were a buyer agent, my buyer would never, ever be told you can get an existing survey. I put it in writing. If they chose to do that, that's on them, but they don't have one.
Yeah.
Yeah.
Okay. That's good.
And the reason I'm telling you this is because not only have articles been posted regarding the concerns of copyright and the infringement by brokers and agents, it's costly to you. We had one agent who used copyrighted photos that the seller gave them from a CD when they bought a high-rise in Houston. That cost that agent close to $10,000, and they had to pay it. As I said, you don't purposely violate those things. And you can't say you didn't know because the copyright protection is on the product. Big problem. So again, on our seller's disclosure, we decided at the last minute to go ahead and strip that as well, because we realized that this is going on way too much. And the more we assist in making sure our forms don't encourage this when agents are absent, not paying attention to what they're providing. So Section 9 will also be removed from the seller's disclosure. Any questions? Okay, now I showed you this last month, but this is the buyer's walkthrough and inspection form. We did approve it. We have a new section for re-inspections, residential service contract, and sight unseen. This is really an acknowledgement by the buyer of material facts. We had one agent in Texas realtor write in, and she said, I think this is unbalanced. This looks like it favors the seller more than the buyer. No, it's either factual or not. It's not about favoritism here. Either you did it or you didn't, folks. And the more we understand that, instead of saying this form favors one party over the other, anything here is not what you think. It is what happened. That is a fact. That's not something that we're going to be able to misinterpret. So you either did re-inspect the property after you agreed to repairs with the seller, or you didn't. You either bought a residential service contract or you didn't. You either bought this property and you never visited or revisited. We're going to talk about removing the word reviewed and probably put viewed in it. Or you chose not to. One or the two. It's either or. This is not something that is favoring the buyer over the seller. It is truly about factual activity that happened. Any questions? Okay. Now what we're going to do is review. I'm not going to do it in grave detail because we're going to probably point that out next month as well. My concern is leases are probably the one area where it's required of law. All this language is statutory language that's added, but very few landlords and tenants read it. And most of realtors, while they may have read it at one time, if you don't do a lot of leases, you could be in the situation of having to really brush up and attend training for leases. Now, the first revision of the lease applies to this renewal, and it says they added a provision that says a paragraph 4B applies only if the lease renews on a month-to-month basis. Okay, so they had to get clarity on that provision in 4B. Now in paragraph 5, lots have changed. They stripped out a lot of language and made it much simpler and straightforward. It says monthly rent is $, period. Pretty simple. For the last paragraph of paragraph A, it says tenant will pay first month's rent made payable to either the landlord or listing broker. Remember that? It changed in the lease listing. Well, it's balanced here in the lease. And it says the first month's rent is due and payable not later than a date by, and then the method. Prorated rent, much simpler. The prorated rent of X number of dollars is due blank. Okay, very simple, straightforward. But they had to clean this up quite a bit, make it simpler for the parties, and then the acknowledgement that the tenant knows that they're instructed to make the first month's rent made payable either to the landlord or the listing broker. Big change on something like that. The next change is, remember how in the lease listing agreement in paragraph 20, instead of having information about pets, they have animals. And it says that unless the parties agree to otherwise in writing, tenant may not permit, even temporarily, any animal on the property. That's a given, right? And they define some of the pets you can't keep. I know we had one tenant who got a fish tank, and the landlord held them in breach of the lease on something like that. Yep, very important. But it says an assistance animal is not considered a pet, but is still required to be reported to the landlord with accompanying documentation as required by the Texas Department of Housing and Community Affairs. We've talked about this. This is the documentation where a landlord could rely upon a health provider for the prospective tenant to the reasons and the acknowledgement that they are subject to an assistance animal for a quality of life, improvement of life, or to perform some function for them. The rest of the changes basically are removing the word pet and putting in the word animal, same types of provisions that the previous lease, the current lease has. The next one is HOA. This is in part to, we had too many listing agents who failed to help the landlord, the owner of the property, attach the HOA rules to the lease. And no tenant can abide by them unless they have what? A copy of them. And more lease listing agents didn't do that. the tenant agents didn't pay attention to it. So now it's been changed. This property is or is not a part of an HOA. Put the name there. And then all of the rules and all of the requirements are going to be a part of the addenda that you will mark and prove that you've done that. The next one is prohibitions. Based on the property managers that we had, they needed to add in subparagraph 5, any illegal or unlawful activity. Then they had to clarify, including but not limited to the planting and growth and consumption of cannabis plants or products, so that landlords' rights are in writing and the tenant knows that they have to abide by them or be in breach. The number of guests. Well, currently it says you can stay for so many days without written permission from the landlord, whichever is less, right? But no guests are permitted to stay on the property more than twice the number of days in the space above in any 1 month. If the above space is not filled in, 2 days total per month will apply. And that was because agents really were remiss in making sure that a value was put in there so that the tenant understood what they were able to allow for guests to stay without the written permission from the landlord. Again, many times when we make these changes, we put everything that's been in a wish list because it's very costly to go through this process and change our forms. The next one kind of parallels what we did on the buyer's walkthrough form, right? And in this paragraph, it says sight unseen notice. Tenant is given the opportunity to inspect the property prior to signing the lease. A tenant who declines to do so and chooses to sign the lease on the property sight unseen does so at their own convenience. Tenant accepts the property as is, and landlord is under no obligation to make any changes upon tenant viewing the property. Tenant will be bound to all provisions of the lease, irrespective of tenant viewing the property before signing the lease. Big thing here. We've had lots of these happen in the last couple of years, and tenants just think that they get to tell the landlord, well, you need to do this, this, and this, when the tenant didn't even inspect the property prior to signing the lease. The next change that we will have is regarding the tenant's responsibilities on the property. Notice that we have quite a few of them, right? Well, they added one. And the reason they did is because you know how tenants are. When a landlord holds them in violation, they go back to their lease to say it wasn't in the lease, right? So the tenant's responsibility has changed to change in supply and change water filtration systems, including but not limited to refrigerator water filters. So they had to add that. Evidently, they'd had enough disputes as property managers on that. I've seen some property managers rules that the landlord puts on there, and they kind of take in everything that they've ever had problems with so that the tenant is aware they're responsible for it, because if it's not clearly denoted, many tenants say that's not what you put in the lease. The next provision that changed on the lease was basically default, and they added a provision that said all unpaid amounts, including judgments. You know, when the landlord takes the tenant to the court, they have judgments. They'll bear 18% interest or the maximum amount allowed by law per year from the due date, compounded annually. So they had to add that as being one of the default abilities by the landlord. Excuse me. The next one is on the addenda. They added the addendum regarding rental flood disclosure. Remember how it's been added to the lease listing? It's here, and it's already marked, which means what? That's required by law, so that has to be there. Notice all these other addenda. You better have all of these marked if the landlord and tenant have agreed to these things. The landlord's rules and regulations, right? The owners association rules, that would be what we just notated about the HOA and those type of thing, or the condominium association rules. They're systematically getting rid of fax numbers almost everywhere, and they're adding another email line, and they're going to try and be consistent throughout the forms to give the same number of lines and the same type of thing. Now, this is important because this is information that the parties generally acknowledge. This 1 in F talks about in the event an occupant over 18 years of age dies during the lease, who's going to be responsible to respond to the landlord? You put a name and address and phone number. And in the event, the estate will come forward and find a way to terminate with the landlord based on this provision in G. So it's real clear now. Before, it talked about a lease wasn't even, there were issues that we had regarding that the lease would go on and the estate would be responsible for the lease. And it does in the event now that the estate representative knows how to terminate with the landlord properly so that the estate is not responsible for that. Any questions? Again, we'll probably go through this a little bit more next time, but I mean, lots and lots of changes on the lease. And here's the biggest issue that we have for you is you're a tenant agent and the landlord's representative says, oh, here's our template. You better look down in the left-hand corner. If it's not going to be the current date for the lease, your tenant will not use it. You're going to point that out to the other broker that the lease has changed. So be careful. That's one of the things we have for a long time. I still get leases from 2001. They've been repealed by law many times. It's very deadly for brokers to use repealed lease forms because they're usually complying with the law that we have. Any questions? Now, what you see is the draft. Now, I wasn't a part of the leasing task force, but I'll know in a few weeks which ones they approved. These are probably the ones I'm going through now are the ones I know that they will approve. There's been some additional ones and new ones too. But they changed, of course, the pet agreement to animal. And what they tell you is that an assistance animal is not a pet, goes through all of this, and that such request may require documented need for the assistance animal. That's what the landlord is allowed. And if it's accepted, there will be no pet deposit, no pet fee or anything for an assistance animal. And it's marked here if the animal listed in this agreement is an assistant animal, yes or no. And so the language just was added to comply with the appropriate terms, spayed or neutered. The consideration, and it doesn't apply to assistance animals. That paragraph was changed to remove the word pet and have animal. Same thing with animal rules and disclosure concerning animals. This is important because the landlord does have a duty to determine if this animal has ever injured or bitten anybody or may have a predisposition to bite or injure someone. Tenant's liability, and the rest was just the stripping of the word pet, and it's now animal. The last form I'm going to show you, where is it? Was an amendment to the lease. And the amendment to the lease is really a form that is used most often by property managers. The lease amendment is a newer form for us. It's been in the last couple of years that we've had it, but we don't use that if we're a lease listing agent or tenant agent unless the lease has not commenced. Because once the lease commences, we're out of it. That's between landlord and tenant. And they added a provision that kind of cleaned it up a little bit and then added a consideration, because in the event the lease will be amended to maybe add an animal, not an assistance animal, but an animal or any other provision that would require consideration by the landlord. Okay, any questions on those drafted items? Any questions? If you put it in chat, you can take yourself off of mute and ask me now. Okay,
Hey, Marilyn, it's
Uh-huh.
Mary. It's going back to the question about the surveys.
Mhm.
So just for clarification, sorry, I'm trying to see. So as a listing agent, we're only sharing or asking our sellers to share that if they have the original survey that they themselves purchased. Is that, I'm trying to
And
understand.
not copyrighted.
Okay, so basically they can't have gotten it. Well, okay, so they can't have gotten it just from a copy from the previous seller, basically.
No, that's not their survey. It doesn't
Okay,
have.
sounds good.
Yeah, and when I say copyright, I mean, you check it over. You are not gonna participate in that unless you have a pile of money somewhere hidden away that you're gonna be able to defend yourself in the event this lawyer's threats of a class action lawsuit go forward on something like that.
Okay.
That's what it is to
Uh-huh.
this.
And as far as submitting a copy online in the attachments, that's fine, as long as the original,
As
or are
long as
we not
it's
supposed to
not
do that?
copyrighted.
Okay.
Mhm.
So as a buying agent, it's better to be safe and sorry and just have your client get a new survey.
Amen.
Okay.
And I don't really care how they negotiate who pays for it, but that would be your best practices.
Okay.
And we spent a ton of time talking about it because it's in all of our publications this month. Trek is talking about it. We're stripping it out of the seller's disclosure just for informational purposes, right? And there's a big reason for this. Agents don't pay attention to it. We had one agent who said when they got the survey back from their buyer, they noticed that it said this is for this transactional use only. What do y'all think that means? You don't get to use it again. Okay, so pay attention to that. And the broker was saying, she said, when I read that, I thought, oh my gosh, they can't ever give it in the future. There you go. That's exactly right. And my problem is we're in a state of change in everywhere we turn in this world, right? And realtors are no different. We're fighting battles at NAR, class action suits against us, and MLS use, and all these different things. But the one thing we can do is establish our best practices and always abide by them. You know, you might have your own checklist because you better, because that's a way that you're assured on each and every transaction you were consistent. This is what you did. You never deviated from your best practices. We had an agent one time years ago who was sued, and she was sued by the buyer, right? And the buyer wanted to blame the agent for not having told them something or advised them something or whatever they were doing, right? So what happened on this was when the agent and I met with the attorney who was going to represent herself in the brokerage, she came in with volumes. Now this is going back a while, volumes of documentation, 5 binders. You know why? This buyer, she had been with this buyer and they had 4 contracts that they put in that they terminated during the termination option. And then the 5th one, the buyers decided to go forward, right? Well, the interesting part on this was it really resulted in the attorney laughing and being so ecstatic. They had never represented a realtor, an agent that had such good documentation. And what did it prove? The attorney was very clear. It proves they had best practices and they did it each and every time. Now she was cleared of it, but she left the business. It was overwhelming for her. She did the right thing, but got sued. We had a judgment against them because they lost, right? And years later, they contacted me and asked me if I would release that judgment. The wife was going through cancer treatment and they needed to sell their home. And I said, I will partially release it, but never release it. And they said, well, you're preventing us from getting a new home. I said, no, you are the ones who did that. Make no mistake, there are just sometimes we have to stand strong. I knew the agent who contacted me in benefit of these individuals, and then I had to visit with the individuals and set them up on a payment plan. That was part of the agreement for me to partially release it so they could sell the property. But make no mistake, your need to establish in writing what your best practices are for each type of transaction. And then you will never deviate from it. I don't care if you represent somebody that is your dearest friend or someone you're related to. You just never deviate from it. That is your biggest ability to always prove that you did the same thing each and every time. Couldn't offer you better advice on this last day of May in 2022 than to do that. Any questions?
Yes.
Thank
and then-
you.
Uh-oh. You can go
Just-
ahead.
Thank you. Sorry, just wanted to say thank you, Marilyn. And I wanted to ask, what are your thoughts on how the title company is involved with these surveys? Because when I first started, we would always ask the title company if they approved of the survey. And if they said yes, then okay, we can convey it. And so will they be involved in this at all?
No, they did not provide it.
Okay, so it's because we're providing it as the brokerage. It's all going to be on us, right?
The seller. And who do you think the seller's going to blame?
Us as their realtor and brokerage.
Exactly. So that's why I'm kind of mentioning this. Anytime I hear this conversation that goes on for over 20 minutes on one of our all-day meetings, we all perk up. And they're from realtors and around the state as well. But this one kind of ran through every transaction we were talking about, almost all of our documents type of thing. So yeah.
Yes, I just took a legal 2 CE class, and even the instructor in the class and the title company that was there when we brought this up. And I said, you know, because you have been talking about this the past few times, even the instructors and title companies are saying, oh yeah, if it's still purchased by the seller originally and it's originally the seller's survey, then they can convey it once, not twice, and things like that. But no one in the industry is talking much about the copyright laws. And so I think this is a big thing we need to all perk up on.
And I'm going to tell you, because they're not subject to them. See, they're not violating.
Yes.
Your seller and you are.
Makes sense. So it doesn't matter to them. They're not liable.
They'll never get in trouble.
Makes sense. Well, thank you for always keeping us aware of things that are coming up before anyone else is
I know, my
talking about
pleasure.
them.
Mhm.
And then regarding the seller side, so you think best practice would likely be, if we're representing the seller, just to go ahead and get a new survey for the buyer. Basically.
Or negotiate. They don't have to pay for it, but don't accept 6C1. That's a huge liability for any seller. And I wouldn't do it. If I were, a seller, I wouldn't give it.
Okay, so just make sure that there's a new survey, but either, of course, the seller or the buyer can pay for it.
Mhm. And as I said, we were thinking that Trek is going to pull that language out of 6C1 out of the contract because of the copyright issues that were experienced. You know, nobody wants to be involved with something that's that straightforward. You either did it or you didn't. You know what I'm saying? Nobody's interpreting that, you should have done this. You knew this, one or the other. So, all righty. It's a happy Tuesday, right? It's going to feel like Monday all day long, isn't it? Okay. So now we're going to talk about terminate. Oh, yes. Did anybody have a question? Okay.
Yes, ma'am. I'm sorry. I had a question. So with the recording, our internet keeps cutting in and out here. Will this recording be available? Because I feel like it's really great information. I can't hear all of it.
Yeah, I'm pretty sure it said in the very beginning that it's being recorded.
Okay, yes, ma'am. Sorry, we couldn't hear that part. Thank you.
Yeah. When you come in, it gives you the notice. It has to tell you that you're being recorded, that kind of thing. Now, terminate or default. So now I'm going to go through some provisions in our agreements and the contract. They clearly use language. Okay. And that's what our job is to use this language properly. So we are going to go through The first one, I gotta get down there. The first one is in our listing agreements for sale, right? And it's involved with broker compensation. Talks about when our compensation is earned and payable, right? It's earned when the parties sign a contract. It's payable upon closing and funding, or it's earned if the seller breaches this listing. Remember how we had in the revisions in the new listing for sale where it says that if seller does not cooperate with the showing and the marketing and anything else that involves the transaction, they'll be in breach of the listing. Well, here it is. If they breach this listing, we get our commission. It's earned. It's payable when it closes and funds, or if seller breaches the listing. We have had several sellers recently that were under contract, and the listing agent said the seller wants to terminate. No, the seller has no provision to terminate. The seller would be in breach, and that's what we call default. So there's very specific language. When you breach something, you're in default of it. But either the listing agreement, could be the lease, could be the contract. But if you don't have a provision that is clear in the contract or addenda that says you get to give notice and terminate, you don't have a right to terminate. You'll be in default. Big, big difference. On the buyer tenant representation agreement, we have it here in paragraph 11 when it's earned and payable. It's payable if client breaches this agreement. We've had more buyers who think they can sign a buyer tenant agreement with one brokerage and then jump to another. Well, no, that's not true. These are exclusive agreements. True, your broker is the one who'll make the disposition regarding the breaching of the agreement and the termination of it and what they will pursue. But the language is clear in our agreements. If you don't do this, you will be in breach of the agreement, which means that they would be in default of the agreement. They wouldn't have a provision to be able to terminate. Now, in this one, we have the ability to talk about 2 paragraphs. This is our contract. And the first part is going to be paragraph 9, right? And the reason I'm going to show you this is because this is the reason many buyers are in default. Okay.
Ma'am,
Yes.
can I ask a question before you go there? On the sales percentage, what if the seller requests a lower percent and wants to give the listing agent 3% and the buyer's agent 2%?
Well, that's in our listing agreement. The seller knows about that.
So do you try to convince them to make it equal or make it,
That's your decision as the brokerage. Here's
Okay.
my thought. I never offered less than what was normal and customary.
Right. Exactly.
I mean, I believe in our industry. You can
Yeah.
call me all the names you want because I'm very strict about that. But if
Yeah.
we don't protect our industry, we won't have one. See, what they're trying to do with MLS is get rid of it.
Right.
What in the world do you think that will happen to the way we conduct real estate?
Exactly.
Yeah, it's devastating. But
Yes.
yeah, I
Okay,
agree.
thank you.
In the closing in the paragraph 9 of the contract, it's very clear. The closing of the sale will be on or before this date, right? And it says if either party fails to close by the sale by the closing date, the non-defaulting party, defaulting, may exercise the remedies contained in paragraph 15, which is part of our contract, which says default. It is a balanced paragraph. It gives the seller the same rights as the buyer. So if one party is in default, the other party gets to do these remedies. If the other party is in default, the same thing applies to both parties, but it's default. It's not terminate. If your buyer doesn't come to closing on the closing date, they're not terminating, they're defaulting. Use the right language. Reference them to paragraph 9, point to 9 and to 15. You're not being a lawyer doing pointing. You're knowing the forms, the promulgated forms that the buyers and sellers are required to use when they have license holders. Very, very different than using the language the buyer wants to terminate. Buyer gets to terminate if there are provisions in their agreements or in the contract or addenda that says if you do this specifically and follow the notice, then you get to terminate. Otherwise, you are what? You're in default. So let's not sugarcoat any of this. It's very important that they understand this is a legally binding agreement and what the other party can do to them if they're a defaulting party. And again, it's very negative. I understand, you know, it's hard to talk about on the altar when everybody's getting married. How are we going to divorce? I mean, it sounds like the same type of thing, right? You're very positive about going into a contract, but now we're talking about how we could end it. Well, it's all through our contract and addenda provisions to be able to terminate. But there's also a real emphatic understanding, a party that would be in default, not have a right to terminate. Okay, and I'm going to prove it to you. This is a promulgated by TREC form. Notice the buyer's termination of contract. Texas Realtors adopts every form by TREC. Notice it says buyer's termination. So Marilyn, you mean if a buyer doesn't have one of these provisions, or I cannot specifically point to a provision in the contract or addenda, they don't have a right to terminate? Bingo. And it's real clear that you will never misuse this form. And we have more agents misusing this form in behalf of their clients, and their clients being in serious trouble. Okay. The first paragraph I'm going to point out to you, it says the unrestricted right of a buyer to terminate the contract under paragraph 5 of the contract. Well, paragraph 5 says that the buyer, they have to pay for the option in order to get something. We have more agents. Our poor listing agents have to deal with this all the time, in the sellers. Buyer has not received the option fee, but they sent this form and saying, I'm terminating based on that. You cannot terminate unless you paid the option fee. So buyer's agent, you better have that receipt of option fee in your possession before you help your buyer terminate based upon paragraph 5. Otherwise, you're in serious trouble. You've now helped your buyer not comply with the terms of the contract. Everybody understand what I just said? Because this is one that is totally misused. The second one says buyer cannot obtain buyer approval. That's paragraph 2A of third-party financing. You go past those number of days, folks, you don't get to use this form. You don't have a right to terminate buyer. You will be in default. Paragraph 3, the property does not satisfy property approval in accordance with the third-party financing addendum to the contract. Buyer has delivered to seller lender's written statement setting forth the reason for lender's determination. Either this is done 4 days prior to closing, because that's what 2B requires, or your buyer doesn't have the right to terminate. And they better deliver the lender's written statement. Otherwise, the buyer hasn't complied with the terms of the ability to terminate and give notice. Paragraph 4, buyer elects to terminate under paragraph A of the addendum for subject property to mandatory membership in a property owners association. A1, A2, and A3s have provisions that might allow the buyer to give proper notice and terminate. 5, buyer elects to terminate under 7B2 of the contract relating to the seller's disclosure notice. This is how we know how many bad listing agents there are in the world. If you get to use 7B2, that means your buyers are going to receive the seller's disclosure within so many days. And upon receiving it, they have the ability to terminate the contract for no reason. Just use that provision. No listing agent worth anything would ever allow their sellers to disclose that and use that provision. Paragraph 6. Buyer elects to terminate under paragraph 3 of the addendum concerning right to terminate due to lender's appraisal. Buyer has delivered a copy of the appraisal to seller. That's one of the requirements. is that they will deliver the appraisal and within so many days provide the appraisal and the notice of termination of contract pursuant to paragraph 3 under that addendum. 7, buyer elects to terminate under 6D of the contract. That's objection. 6C for residential condominium contract because timely objections were not cured by the end of the cure period. And 8, it says identify the paragraph number of contract or the addendum. You don't write in that your buyer lost their job. The buyer wasn't relocated. You don't write anything in other than pointing to the paragraph in the contract or the paragraph in the addendum that allows your buyer to give written notice to the seller and terminate the contract and get their earnest money back. You cannot use this form if the buyer is in default. Any questions? Okay. Well, then I don't want to see any of you misuse this form ever again. If the sellers receive this form, and the buyer said, I have an unrestricted right, and they didn't get the option fee receipted, that seller can come after the buyer agent, the buyer's broker, and the buyer. This is serious. Do not misuse this form. Now, this one is the notice of seller's termination of contract. And why did we just get this form a few years ago? Because TREC allowed in the contract in paragraph 5 a provision clearly saying that if the earnest money was not deposited per the terms of the contract by the buyer, the seller had the right to terminate the contract. Okay, so that's paragraph 1 of this, right? That's going to reference that the buyer failed to deposit the earnest money per the paragraph 5. Now 2 is identify the paragraph number of contract or the addendum. 2, this poor seller was there at closing and the buyer never showed up. It never closed. Seller uses this provision, says paragraph 9 closing. Buyer did not close by the closing date. Otherwise, they either have a provision during the contract, if they fail to deposit the earnest money, they can terminate, or they have to wait until when? After the closing date. Any questions? Sometimes we have sellers whose buyers say, oh, my lender says they need 2 more days, right? Most sellers won't agree to any extension of the closing date unless the buyer actually does something. They can agree to extend the closing date. Can a buyer force the seller to extend the closing date? No, and I wish every buyer agent understood that. We have more that are so emphatic that the seller must extend the closing date. No, I've only seen one time where a seller, the attorney for the buyer, and the buyer had to pay their own attorney. We don't pay buyer's attorneys. We don't pay seller's attorneys. And the buyer's attorney stepped in and said, the buyer's never given you a notice of termination. We are closing on blah, blah date. And the sellers then had to get what? Their own attorney. We usually don't want to have the parties in a dispute, right? And everybody wants to point the finger at someone for not complying with the closing date. The sooner the buyer knows they can't perform on that closing date, the more they probably need to try and get it amended. But again, a seller is not obligated to do that. We've had some sellers, bless their hearts, that extended it 3 times. And then the poor agent calls me on the 4th time. And I'm going, I don't know about you, but I think your seller has gone way above in this market to keep extending it. But again, it's what the parties agree to. It's just we have very few sellers that are readily accepting amending the closing date unless it's going to be very clear, close to the original closing date or something happened. Any questions on that? Okay.
Roland, I don't have a question on that. I do have a question. I apologize. We're having internet connection issues here. So I missed most of the beginning of your course today. On the drafts that are presented, are these final approvals just waiting for them to go into effect? Or is this something that we can still weigh in on?
No, you can't weigh in on it anymore. The cutoff date was May 6th. My
Okay.
task force, I told you which ones are the residential documents. We did approve those,
Okay.
and those are going forward. I will have a completed list of all of those approved by the commercial, by the leasing, by property management, and residential in our meeting next time. And Texas Realtors attorneys told me that most likely they'll be available and posted for use on our third-party vendors and at Texas Realtors by the middle of July.
Okay, mid-July, and then in effect September 1,
No, they'll go into effect immediately.
immediate. Okay, all right. And then I noticed, because I had the front desk print me out some copies, I was hoping I could follow along with by using copies and hearing every other word you said. But on this, some of these say like page 16 of 7 or page 17 of 16. Just
Disregard all the page numbering and lettering. They've
okay,
taken care of all of
Yeah.
that.
okay. So,
They're
all right,
very-
I'll go back and watch your video. Thank you so much for this.
All right, we're ready for the rest of it? Okay. Here's what I'm going to share with you regarding something that happened so that everybody understands. The listing agent and seller were just so giddy because they got the buyer to sign a waiver on the addendum concerning a right to terminate due to lender's appraisals. Just as giddy as could be, right? And then the buyer terminated the contract based upon 2A of third party, which is buyer approval. Here's what the buyer agent did. The buyer agent told the buyer, you're not going to get this property if you don't sign that total waiver. But get your appraisal during your termination option so that we still have a number of days in the buyer approval and third party to terminate if you're not individually approved. And that is exactly what happened. The appraisal came back $60,000 difference from sales price and appraised value. Buyer tried to negotiate with the seller. Can they do that? Yeah, they can. Seller has every right to say no. But they tried to negotiate because $60,000 was not doable. The lender came back and said, this buyer barely has the money to close. They never had the ability to waive an appraisal. But that was how the buyer agent coached the buyer. So buyer turns up, gives their notice based on 2A, buyer approval. The lender says they're not approved. They can't make up $60,000 difference. So now they're not buyer approved. Has nothing to do with the property. They terminated. The listing agent and the seller were bent out of shape, and they shouldn't have been. These provisions are separate. They're not lumped together. And while you may have had a waiver, paragraph 1 or 2 on that addendum concerning right to terminate, it doesn't take away the buyer's ability in paragraph 2A if they're no longer approved with that waiver. So be very, very, very careful about what is going on. Sellers need to know every provision that a buyer may have in the course of this transaction. And each one's different because we don't know all the addenda that are on there, and that the seller may have, the ability to say, I'm sitting here waiting for the buyer to give me written notice if they're not this. Yeah. Yes,
Sorry to interrupt you, I have a question. If we are the listing agent in that scenario that you just shared, and as part of our due diligence, when we are reaching out to a buyer's lender to follow up on that pre-approval letter, if we've received one of those waivers, can we add that to our question? Like, can we ask the lender, we've received this waiver, do they also have the funds to cover that they're claiming that they have
the
waived?
buyer gave you permission in third party. It's right above where party signed that the seller or agents have the ability to contact regarding the status of approval.
Thank you.
And truthfully, even in this market, we're adjusting this market. You notice how the builders are adjusting first. Remember, I talked to you about that. They've got inventory. They've got to remove a number of units. So they usually have a better adjustment when our market starts to maybe have difficulty or shifting. Sellers are usually the last. They don't want to believe that they can't get $70,000 over the list price, right? So again, if I were representing a seller, I would encourage them, and I would also contact the lender and be very emphatic. We received an offer from X. They have now totally waived. So you've given them a blank check to make up any difference between the sales price and appraised value. Yes or no? Yeah, and as a seller, I wouldn't agree to it unless the lender provided that.
I have a question. So in that case, the seller agent could be the only one to contact the lender, but not the owner. Is that right?
Oh, no, both of them. Mhm. The
Okay,
buyer gives permission to everyone.
got it. Thank you.
Yeah. And truthfully, there are so many things that we give advice to our clients. We advise our sellers, you still haven't gotten a valid proof of funds for this cash offer, right? How would you take your seller to proceed? Jump in? And no, you're going to caution them, because we have listing agents who have received snapshots, images, and their sellers made a decision on that? I don't think so. Your seller's going to get a signed document from someone saying and validating the funds. You never know what people are going to do. And we've had unfortunate situations where the document that was sent by Snapshot was altered. It wasn't true. That's fraud. And you don't want to be a part of that, nor advising your sellers to accept something that is not independently verified and something like that. Okay, who gets to solve all these legal disputes? Say the release of
Judge.
money. Yeah, either if the parties don't come to a mutual understanding, it's going to go before a judge, and could be a jury. And so the problem is that we're not the party that's going to resolve this dispute. While we could give information and point to provisions, our clients are the ones that are going to have to defend this or go after them. We're limited on what we can do, right? We can provide forms and processes. So I'm just going to tell you that we don't get to resolve these. While we have sometimes pathways to how it could be resolved between the parties, and I always encourage mediation or even informal mediation, right, between the parties. But we're not going to be the ones that are going to say, we're going to solve this, right? If that was the case, we'd never have disputes, because I know exactly how to solve everything, right? So do you, right? You absolutely do. It gives us the handbook in the contract and addenda. It's pretty clear cut. We don't have to worry about making a decision about it. But again, those disputes are going to have to be resolved by your clients, and they're costly, very costly. So we don't usually want to go into a contract knowing that your seller did not rely on verifiable information, or that the documents that were received were not, you know what I'm saying? There's all these different components. While your seller could make a decision to move forward, you're going to have an arsenal of information verified in writing between you and your clients that says you didn't advise them to go forward unless you had this. We had a lawsuit in one of the operations, and it was ridiculous. We represented the seller. Seller was advised by the listing agent, we need proof of funds. They kept trying to get it from the buyer agent, right? The buyer agent says, oh, it'll be coming, it'll be coming, it'll be coming, right? But I can vouch for them. Well, no seller relies upon what any license holder says about the client that they represent. Okay. I hate to burst your bubble, but they don't. They just have a process that they follow. And what happened on this is that the seller went ahead with the contract, even though they had no proof of funds. It was a multi-million-dollar property. The seller went out and got a lease because his new building of his new mansion wasn't going to be ready, right, for quite a while. They sued the listing agent, listing broker, the buyer agent, and the buyer agent brokerage. Well, I don't know about you, but if you don't know your buyers well, you're relying upon what? Their representations to you. And sometimes we can get involved in this situation, but this buyer was a scam artist, and the seller was advised by our listing agent not to go forward until we get something, we haven't validated that they've deposited the earnest money and all these other things. So just make sure you've got everything in writing, that your advice to your clients is in writing to them, and then you have their response, right? Sometimes it could come back in a text, I don't care, you better save that text forever. Upload those in your closed documents so that we have them forever on something like this. I'm not trying to be a naysayer about it, but we're seeing too many crazy things go on. And as a listing agent, if you weren't aware to tell the seller, look, well, we got this appraisal waiver on this addendum, they're going to totally waive it. That doesn't take away their right to terminate if they get the appraisal back before these number of days in 2A and now are not individually approved. They would still be able to terminate and get their earnest money back. If you said that to your seller, what do you think your seller's response would be? What? Yeah, but that's how you have to be. You have to explain that to them within the context of every other contingency that the buyer may have on the contract. Use those time limits I gave you.
Marilyn,
Yes.
not to mention a few months back, we had a buyer who waived their appraisal completely, or their right to terminate based on the appraisal completely. And because the appraisal came back so far off, they still elected to just lose their $3,000 earnest money over the fact they were going to overpay by $50,000, and they have that right, correct? So I think we should be advising sellers that
They don't have a right. We don't advise people how to default on the contract.
Oh, no, I didn't mean that. I was representing the seller. I'm saying the buyers still said, well, we're going to walk away and we'll just lose our earnest money and walk away because we don't want to overpay by $50,000.
Paragraph 15 default says that the seller can come after you for any damages, including earnest money, but not just earnest money. That would be a seller's choice. And in this market, if I were the seller, you already know they have money because they have a cash down payment in paragraph 3 of the contract. I'd go after them in small claims court for all your damages, not just earnest money.
Okay. So, but basically they're going to have to go to court at that point and sue for default.
Yeah. They'd go to small claims court. We don't solve that for them. That's where those legal disputes result in judges and juries. And I'm going to tell you what I found in small claims court. They handle all these landlord issues and disputes and evictions and judgments and stuff like that. We've had quite a few that have been involved in what we call the justice courts, the small claims courts, because they're under $10,000 in the dispute, right? We've had them where the jury has made a decision and the judges, and every time we have prevailed. And that's because they're looking at what did the parties agree to. And so when our sellers and our buyers do things and they go to these justice courts, it may take a while, but if they have a provision for the contract and the other party didn't, they certainly have the right. We would never diminish paragraph 15 default. We would never tell the seller, you need to just let this go, or you need to, they can make that decision, but we're only going to point to the paragraph. We're not going to give legal advice on that. Any other questions? Okay, good people. So next month, we are going to review the list of all the forms for Texas Realtors that were approved and are going to be posted for our use, because you have to know what is the current form in order to be able to make sure that you never violate and misuse and use a form that is not current. Even for Texas Realtors, the lease is really the one that I see the worst abuses of, because the landlord has had a template for 10 years and they really like it. Well, that's stupid. The law's changed over the last 10 years and the landlord will not be providing the tenets of law. And so anyway, we have to be very careful about that. But that's what we'll talk about next month. And then we'll be scheduling very training regarding the changes and how you'll do it. And we're going to go back to the leases. And the reason for that is we have a lot of leases. Look at what the stats were, what Bob Hale talked about. 40% of your purchases involved what? Investors. So if you don't think leasing's not going to be a big part of your market, you're mistaken. My concern is I want you to do it perfectly as a lease listing agent as well as a tenant agent. So we'll kind of touch on the points that you need to be referencing in handling those types of transactions. All right, good people, please take care and stay safe and well, and I'll see you next month.
Thank you, Marilyn.
You're welcome. My pleasure.
Thank you.
Thank you.
Thank you.